Good afternoon, everybody. This is Jennifer Schaus coming to you live from Washington, D.C. today, and thanks for joining us in our Webinar Wednesday series. Wednesdays in 2021, we are covering the DFARS, which is the Defense Federal Acquisition Regulation supplements. And so we cover each of those sections on a weekly basis every Wednesday, 12 o'clock Eastern Time, which is where we are right now. All of the webinars are recorded and they're posted on our website and also our YouTube channel, which now has 450 complimentary government contracting webinars. And they're organized on our website by topic. If you go to YouTube, you could probably just type in whatever it is you're looking for. And our speakers are attorneys, consultants, and other subject matter experts. We do have a couple words to say as far as thanks to our sponsors. So we want to thank the National Veterans Small Business Coalition. They're a nonprofit trade association representing veterans across the country. They have various chapters. I believe their biggest one is here in the Northern Virginia area. The Virginia PTAC, which is the Procurement Technical Assistance Center, housed over at George Mason University, provides training, mentorship, and online classes for aspiring or small business government contractors. We actually teach some classes over there on GSA schedules. You can see their full list of services through some of these links. And again, the PowerPoint slides will be available on our website and also on slideshare.net. Another thank you and shout out to Set Aside Alert. They are a publication that consolidates small business set aside opportunities. So the women-owned, veteran-owned, hub-zone, 8A, all of those opportunities are consolidated into one daily newsletter that Set Aside Alert sends out. If you've got questions or you want to sign up, you can contact Tom Johnson. His information is there at the bottom of your screen. We also want to say thank you to the Greater Reston Chamber of Commerce. They have a government contracting council that meets on the third Tuesday of every month, and they also have their big B2G, business to government networking event that is happening the first, I believe it's first Monday or first Tuesday in May. You can contact Alicia Field. Her email address is there on your screen for details and information. I believe it's also up on their website. Judy Bratt over at Summit Insight has helped us to promote these webinars. More about her business is on her website, or you could contact her directly with the email address at the bottom of your screen. And a couple training classes that we have coming up with the Virginia PTAC. We have the GSA schedule, What's in It for You, happening May 25th, and then also again July 8th. And marketing and messaging for federal contractors through the Catalyst Center is happening July 1st. You can also register on it for any of these events on our website under the events section. These are all virtual. Okay, quick blurb about us. We are a professional services firm based in downtown Washington, D.C. and help existing and established revenue-generating government contractors with anything from market analysis to proposal writing, GSA schedules, and the back office compliance and contract administration. Our newsletter goes out every Monday, which is probably how you heard about this event, and we reach now 23,000 plus subscribers. That includes both government and I'll say primarily government contractors. This Friday, we have our Government Contracting Live Q&A Cafe, which is a webinar series. We've got 4 subject matter experts. One is our speaker today, Janetta Brewer. So we'll have 2 attorneys and 2 consultants that'll be talking about teaming agreements. You can see the other topics that we're going to be covering later in the year, including subcontracting, proposal writing, mergers and acquisitions, and more. You can sign up on our website under the Q&A Cafe tab. Okay, now for the reason that we're all here today, Janetta Brewer, thank you so much for joining us. Janetta is with Blue Alchemy Consulting. She is a well-recognized and established government contracts attorney, and today she's going to be covering DFARS Part 214, which is sealed bidding. And Janetta, I am going to turn the floor over to you. Thank you for joining us.
Thank you, Jennifer, and thank you everyone for joining the call. So today we're talking about sealed bidding, and we're focused on DFARS Part 214. And so you're probably wondering, why do I have information about the FAR and DFARS and the PGI included here? And it's because whenever we look at an agency supplement, we also need to consider the language that's in the FAR as well. So the FAR is a regulation. It's a huge set of regulations that impact federal agencies, with a few exceptions. There are some agencies that are accepted from the FAR requirements, but generally when Congress or the Executive Office of the President or federal executive agencies want regulations to apply to the federal contracts workforce and or to government contractors, they put those regulations in the FAR. And then the agency supplements allow for agencies who have unique missions and requirements to have additional requirements that impact their contracts workforce and the contracts that they execute, which then also impact the contractors for those agencies as well. So whenever we read the DFARS, there's language in the FAR that applies to that specific section, and then there's supplemental language that the DFARS includes that also impacts that section of the FAR as well. And then particular to the DFARS, there's the PGI, which is the Procedures, Guidance, and Information section, which provides internal DoD procedures, training, reference materials like handbooks and guides and policy level letters for the DoD contracts workforce to follow. So as government contractors, or if we have government contracts folks on the line, if you ever want to know DoD's approach as it relates to any of the sections within the FAR, you would start with DFAR, the FAR section, and in this case, it's FAR Part 14. And then you go to the DFARS to figure out what additional requirements has the Department of Defense levied with respect to the FAR. So you would go to DFARS 214. And then if you want to understand what other policies or requirements or guidance that DoD has issued to its contracts workforce as it relates to that specific section of the DFARS, you would go there to the DFARS PGI as well, and it would provide you total picture of what requirements the contracting officer has with respect to how they're issuing, developing solicitations, how they're reviewing and assessing the offerors that come in, how they're making award decisions. As government contractors, it's very helpful to know and understand the information and guidance that the contracting officers are supposed to follow, because that helps us to understand how we should, within industry, shape our proposals and offers to meet what the government is expecting to see. Next slide, please. So throughout the rest of the presentation today, as we go into the DFARS requirements as it relates to sealed bidding, I'll be providing high-level information as far as this is what the FAR says, and then we'll go into specifically what the DFARS is requiring. But before we do that, I want to provide a big picture view of what sealed bidding is. So if you go into the DFARS, the information on sealed bidding is not that in depth. It's not that much information because, again, it's supplemental information to what's already in the FAR. And so it helps to have a big picture view of what does the FAR require, and then we can get into specifics around the DFARS specific guidance for the DoD workforce. So overview of sealed bidding, it's an acquisition method that contracting officers have available to them. Generally speaking, there are three contracting methods that the contracting officers have available to them. There's request for quotes, which is in Part 13. There's sealed bidding, which is in Part 14. And then there's negotiated acquisitions, which is in Part 15. Part 14 is unique. Not many folks have experience with sealed bidding. There are not many agencies that use it. A lot of the construction agencies, like the U.S. Army Corps of Engineers, NAVFAC, the Naval Facilities Command, and then GSA, who does a lot of the construction contracting for the civilian agencies. They will use sealed bidding a lot, and a few other agencies do, but most agencies typically use the negotiated acquisitions. So sealed bidding is different from the typical kind of submit an RFP, the government reviews and negotiates with vendors and then makes a decision. It's different because there is no negotiation. So the expectation is when the government prepares what's called an invitation for bids, it should include all of the information that's necessary for an offeror to be able to submit a proposal or a bid to the government. And so it has to be completely detailed, accurate, can't be unduly restrictive, has to allow for full competition, and has to include all of the documents that are necessary for the bidder to provide a complete and accurate bid, because as I mentioned, there are no negotiations that are allowed within IFB, except if you're doing a two-step, but let's traditional IFBs for now. For the publicizing requirements, has to publish in public places the requirements that are stipulated in Part 5 related to how acquisitions are publicized for the government all apply here. Submission of bids. The language around submit the sealed bids, in the time and place stated in the solicitation goes back to kind of the old days where the sealed bids were mailed to the government, or you could come and hand deliver the sealed bid to the government, and the bid was in an envelope that the government, opened all of the envelopes together in a big room at one time. Now there is the provision that allows for electronic bids, but again, all of those bids have to be received by the government at one particular time. And then evaluation of bids, as I mentioned before, discussions are not allowed with invitation for bids, which goes back to the importance of ensuring that that initial IFB that the government posts is as complete as possible. And as contractors or government contractors, it's important for us when we're reviewing the IFB information that we provide any questions or challenges that we have to the government related to the information that they include, so that we can be sure that the information that they provided to us is as comprehensive as possible, so that we can develop a bid in response. And then for contract award, again, the thing that's really unique about sealed bidding is the bids are publicly opened. Typically back in the day, I've done sealed bids myself. I've worked for the U.S. Army Corps of Engineers and have leveraged the IFB process many times, and the bids would come in, would be mailed in, or some contractors would drop them off. If we said, bids will be open at 2 p.m. on April 7th, we'd go down to a big conference room at 2 p.m. and we would one by one open each bid and publicly announce the bidder name and the price that was included in the bid, and we'd write that down on a tracking sheet, and then we'd state out loud who the prospective awardee would be based on the lowest price. So that's an overview of the sealed bidding requirements contained in FAR Part 14. Next slide, please. I think we skipped one. Can you go back? Okay. Again, we're staying kind of high level because it'll help us understand better the DFARS requirements. So sealed bidding is the government's preferred method of acquisition, even though it's not one that's used as often. But in the FAR, it says contracting officers shall solicit sealed bids if the time permits, the solicitation, if the award will be made on the basis of price and other price-related factors. So think about competitive negotiations when you have lowest price technically acceptable. In many instances, many of those could be IFBs. it is not necessary to conduct discussions with the responding offerors about their bids, and many times that's the justification that contracting officers will use for not using an IFB method. And then there is reasonable expectation of receiving more than one sealed bid. And the contract type for sealed bidding, it says if you do a sealed bid, you have to award as a firm fixed price, and in some instances you can award it as firm price or fixed price with economic price adjustment clauses. Next slide, please. So that's the background information about the sealed bidding acquisition process and when sealed bidding is supposed to be used by government contracting officers. Now we're transitioning into what are the DFARS guidance that's been provided that kind of supplements the requirements that are contained in the FAR with respect to IFBs. So at the top, you'll have the way that I've structured this is so that you see the FAR requirement, and then when you read the DFARS, you see how the DFARS ties back into what the FAR has stipulated. So in FAR Part 14201-5, there are representations and instructions. So it's essentially saying, contracting officer, when you're preparing the invitation for bid to post publicly, these are the instructions that you should include in that IFB. And one of the sections that's provided is what evaluation factors will be taken into consideration for offerors. And then the DFARS supplements that to require that one of the evaluation factors has to be an evaluation of supply chain risk when acquiring information technology, whether as a service or a supply that is a covered system, part of a covered system or in support of a covered system. And many of you guys are probably aware of many of the supply chain risk clauses, covered information, safeguarding classified information, all of those types of requirements that have been pretty big over the past few years. And so this language was added to ensure that contracting officers are, one, aware themselves that they should be evaluating supply chain risk as part of any offer that comes in under an IFB, and then two, to make sure that they let the prospective offerors know that that will be an evaluation factor as well. Next slide, please. And same here. Hold on. And same here. So if there's a two-step sealed bid, if you'll see in step one, it says that with the two-step sealed bid, you have the technical proposal that comes in first, and the government reviews the technical proposals. This is one of the few instances where with an IFB, discussions or negotiations are allowed. And so in review, evaluation of the technical proposal, when the government says that they have, they're moving forward with evaluating those technical proposals. If you look at the DFARS 214-503-1, step 1, it's also just now advising the government contracting officer that one of the evaluation factors has to be the supply chain risk as well. So essentially in both places, whether it's a regular IFB or a two-step sealed bid, the government has to consider or evaluate supply chain risk. Next slide, please. Again, additional information for the government contracting officer in the DFARS. So there's a requirement you saw up front where it says if you're going to use the sealed bid, one of the requirements that the government has to consider is that they're expecting to receive more than one offer. So sealed bidding shall be used unless, and that one of those exceptions was if there's expected to only be one offer. So say the government contracting officer issues the ISB, only receives one offer. DFARS, DOD requires that if the government only allowed less than 30 days for receipt of offers, so generally speaking, ISBs or solicitations on the street for 30 days or more, if there's 29 days or less that the ISB was on the street, and only one offer was received, then the government contracting officer is going to have to cancel and resolicit for a period of at least 30 more days. And this serves two purposes. One, DOD, I'm not sure if you guys are familiar, but a few years back had a lot of conversation around ensuring that they received robust participation from industry. The only way for the government to really know that, one, they're receiving good value, two, that they're receiving competitive pricing that's fair and reasonable. One way for them to know that is through competition, having, several bidders provide bids or proposals in response to their solicitations. And so when they only receive one, there's concern that either what they're, especially around just from a pricing standpoint, it makes it difficult for the government to determine the price is fair and reasonable. So because of that, DOD has specifically provided guidance to its contracting officers that to the maximum extent possible, if they can, they should issue solicitations for more than 30 days. And this language here is language that is really to drive contracting officers to do that, because now contracting officers know that if I issue for less than 30 days and I don't get more than one bidder, I have to go back out and reissue the solicitation for another 30 days. So now I've extended my acquisition timeline by 30 extra days, and most contracting officers are not going to want to do that. So this language was implemented in order to encourage contracting officers to issue those solicitations for more than 30 days. And again, with the cancellation, that means whatever bid did come into the government, it will not be opened. That price won't be publicly read. The ISB will be canceled and then re-solicited. And then that same language is below in the DFARS that says acquisition is greater than the simplified acquisition threshold. If only one offer received, follow the procedures above. Next slide, please. And this is same language. So many times in the DFARS, because it's a supplement to the FAR, you'll have different sections of the FAR that's providing different instructions. And then the DFARS comes in to remind the contracting officer or to add additional language for that specific section of the FAR. So here, again, the DFARS is providing notice to the offeror in the solicitation that we're putting you on notice that if you issue an offer in response to this ISB and we only get one offer, you're now on notice that that solicitation is going to be canceled and we're going to resolicit for a period of at least 30 days. Next slide, please. And same here, another solicitation provision that's putting the contracting or the offeror on notice that if only one offer is received. And also here, there's also a notice that the offeror is going to provide or be asked to provide additional cost or pricing data. So again, as I mentioned up front, typically the government relies on competition to make it fair and price fair and reasonable determination. So one of the things a government contracting officer has to do when they're evaluating offers that have come in and before they make the final award determination, they have to one, ensure that the contract or the offeror is responsible, but then two, they have to ensure that the price that they are making the award for is a fair and reasonable price to the government. And so when there is no competition, the government has to look at other methods for making that price fair and reasonable determination. And so this is putting the offeror on notice that if only one offer is received, you agree to provide us with additional cost or pricing information to help us make that determination. Next slide, please. So generally speaking, this is just letting offerors know that generally the IFB should have all of the information that's necessary in order for the offeror to be able to submit a proposal. And contracting officers are being advised in the FAR that they shouldn't require descriptive literature from the bidder in order to determine whether or not the products offered meet the specification. However, in the DFARS, it says if brand name or equal purchase descriptions are used, then the provision at FAR 52211-6 satisfies the requirement. So generally speaking, if the government is not in general supposed to specify a brand when it issues a solicitation. So if the government has a requirement for TVs, it shouldn't say contractor or offerors, we're looking for you to provide to us an LG TV. Generally, the government should just provide the specs for the TV that it's looking for. So it should say looking for a TV at least 42 inches and then, with color and HD resolution, and that meets, so those are the specs that the TV should meet. And then the work or the offerors should be able to kind of determine which TVs across a bunch of different brands would meet that requirement. And the goal of that is to ensure that competition isn't unnecessarily restricted. But there are instances where the government is allowed or permitted to specify a brand name. And this is just saying with the IFB that in those instances, you can require the offeror to provide the descriptive literature that helps to demonstrate that what they are offering meets that brand name or equal requirement. Because the or equal piece says, I don't have to give you LG, but I can give you something that's equal to what the LG specs are. And so the descriptive literature helps to provide that justification. Next slide, please. For rejection of bids, so just big picture view, when we're talking about canceling invitations after opening. So as I mentioned, one of the ways that the IFB acquisition process is different is that it allows the government to publicly announce pricing. And as I'm sure most of you know, one of the biggest pieces of proprietary data that a company owns is its pricing. And so making that information publicly available to other offerors, obviously you're providing sensitive and proprietary information that companies generally want to protect. And then two, you're exposing, potential for other companies to come and kind of undercut you as well. So if you cancel an IFB, but you've already publicly announced 5 vendors' pricing for that particular acquisition, and then you go back and resolicit for the same thing, you've exposed all of those various companies for one, and then two, you're creating an instance where the new acquisition is likely not to be fair and competitive and pricing that you would normally get under ordinary circumstances, because more than likely now everybody's going to try to undercut that lowest bid that was announced so that they can, win the award, so to speak. So because of that, cancellations of IFBs can only happen, especially after the invitation has been open. Cancellations can only happen under very strict and stringent circumstances, and a determination has to be made and included in the clause. So cancellation after opening, as I mentioned, in FAR Part 14, I have the language there that says preservation of the integrity of the competitive bid system dictates that after bids have been opened, awards must be made to that responsible bidder who submitted the lowest responsive bid unless there is a compelling reason to reject the IFB and cancel the invitation. Invitations may be canceled and all bids rejected before award, but after opening only when the agency head determines in writing. And these are the reasons that can be leveraged for cancellation, because again, after you've made those prices public, you're creating a situation where likely it's not a fair competitive environment anymore. So in paragraph C is where the exceptions to being able to cancel that IFB, and it has to be made or determined by the agency head. And the DFARS is supplementing that by saying the contracting officer shall make the written determinations that are provided below. So in FAR 14404-1, it says that the agency head has to make a determination, but the FAR has delegated that authority down to the contracting officer. So now it's not the agency head, it's the KO who gets to make that determination that's provided below. So this really provides a good example too of making sure when you're reading the agency supplements that you're also reading the FAR as well, because there are sometimes POCs that are dictated or prescribed at the FAR level that may be delegated at the DFARS level at a lower level. And so it's important to make sure you read the agency supplement as well to ensure that you know who's the agency official that's making certain determinations. Next slide, please. This is another example of redelegation that's happening. One, other mistakes disclosed before award. So again, thinking of just the IFB process and how it's different or unique from regular competitive negotiations. Information is made public, so you're publicly announcing pricing. And then, so this says, mistakes disclosed before award. So say you've announced the pricing, everybody knows, what bidders offered and what prices they offered. And then now you have a bidder that comes in and says, well, wait a minute, I made a mistake and I want to change it. It creates a situation where it could be unfair because one, there's sometimes not a way to know if the person actually did make a mistake. And so the person may be claiming that a mistake was made because they want to revise the bid in order to provide a price that will now make them the lowest offeror and eligible to receive the award. So because of just the appearance issue and just the possibility or impossibility of ensuring that when folks are claiming that a mistake was made, that they're doing with the best of intentions and they're not making or creating an environment for the procurement process to be fair or unfair, mistakes can only be made and corrected under very strict and stringent circumstances. So in FAR Part 14, it says mistakes disclosed before award can only be made under certain circumstances, and it provides in the paragraphs below what those circumstances are. It has to be clear and convincing evidence of the mistake and of the bid that was actually intended. I've had, a few situations of these as a government contracting officer where construction companies would send a note and say, I made a mistake in my bid and I, transposed the numbers and that provided you guys with a price that I didn't intend to include. And so there's a huge process that we go through internally to see if, one, we're looking at the evidence that they provided for the calculations that were actually included in their bid, but also kind of the backup information that shows what should have been the price. And then we review it on our end to see, is it clear that they made a mistake? So if it's construction, for instance, of a building and the bid came in at $2, more than likely they made a mistake. It's easy to kind of capture that. But if the bid came in and it's around the same price as 15 other bids, like it's in the same ballpark as those 15 other bids, it's hard for us to, on its face, look and see that they likely made a mistake. And so in that instance, they wouldn't be able to correct it. But if it's clear that a mistake was made, for one, and then two, it's clear what they intended to bid, which we use the backup documentation to support, then we allow them, then we are allowed to, if it's in the government's interest, to allow them to correct that bid. And then it says if the bidder doesn't want to correct it, but they want to withdraw the bid, there's an agency head determination that can be allowed to allow that to happen, again, with clear and convincing evidence both to the existence of the mistake and the bid that was actually intended. And then if the evidence doesn't warrant the determination, an agency head can then say, we're going to accept your bid as it was provided, and it won't be allowed to be withdrawn or corrected. So the weight is definitely upon the offeror to be able to demonstrate that, yes, in fact, the bid was a mistake, and that what the intended bid should have been based on the supporting documentation that's provided. And in the DFARS, it's delegating the authority level for that. So in the FAR, it says that the agency head has to make the determination. Obviously, you guys know that DOD is huge. And so for the defense agencies, that authority has been redelegated down to the specific agencies, which is like Defense Logistics Agency or Defense Threat Reduction Agencies. Those agency heads are able to make the determination. Next slide, please. So final thoughts around just sealed bidding in general and specifically as it relates to the DFARS. One, although sealed bidding requires less steps than the RFP, RFQ acquisition methods, it's critical to ensure that the bid that's provided to the government is both accurate and complete at the time of submission. One, as mentioned, IFB does not permit discussions or negotiations with offerors, so it's important that offerors ensure that they understand the requirements that are contained in the solicitation, and if they don't, that they make that make it known to the government contracting officer, and that they ensure that the government contracting officer provides the information that's necessary for them to submit a complete and accurate bid. And then two, because there are no discussions or negotiations, and the government has the authority to make the award to the lowest offeror, who's also deemed responsible. And it's important that, again, that information is accurate and complete, because there won't be the opportunity to correct any mistakes without clear and convincing and compelling evidence presented to the government. And even with clear and convincing and compelling evidence submitted to the government, the agency head, or if it's been delegated, they can still deem and determine not to allow the offeror to withdraw or correct the mistake that's been made. So it's critical that the offeror understand the requirements that are contained in the solicitation before they submit. The second thing, lowest bidder is not guaranteed the contract award. Many folks believe, if the government is making a determination based on price, as long as I submit a low price, I'll get the award. That's not the case. Even when discussions and negotiations do not occur and an offeror is not required to submit a technical proposal, the government still has to make a responsibility determination for all solicitations. And so part of the government responsibility determination of offerors includes past performance. It includes the ethics of the contractor, whether they've ever been suspended and debarred. It includes, a check of their financial capabilities and resources to actually perform the work. So many of the evaluation factors that the government looks at in a negotiated acquisition can be reviewed as part of the government responsibility determination. And so offeror still has to be deemed responsible by the government contracting officer, and a diligent government contracting officer is going to be reviewing all of those elements for that lowest bidder. And if that lowest bidder isn't deemed responsible, then, and they still have to make a fair price fair and reasonable determination as well. And I've, as a former government contracting officer, not made awards to the lowest offeror because I could not ascertain that offeror would be able to perform based on the price that had been offered. And so it's still important that the price that is being offered is one that gives the government confidence that you'll be able to perform successfully throughout the life of the contract as well. So you still have to be responsive, still have to be responsible, and the government still has to determine that the price is fair and reasonable. And then the third thing, as I mentioned up front, when reading the DFARS, it's important to read the DFARS as a companion to the FAR. The DFARS is not meant to be read as a solo document. It's meant to be read in the context of the FAR language to make sure that you understand your full rights as it relates to certain sections and to understand the contracting officer's obligations as well. So that concludes my presentation, and thank you, Jennifer.